Secretary, please call the roll.
Senator Rocky Adams, Senator Alvarado,
Here.
Senator Yates, Representative Bridges, Representative Frazier Gordon, Representative Marzian, Senator West,
Here.
Representative Hale.
Here.
We have a quorum.
Thank you so much. First matter of business is approval of the minutes. Do I have a motion for approval of the minutes? Have a motion and a second. Without objection, it is so ordered. Do we need to cover anything before we call our first regulation? Looks good. Please call the first regulation.
Personnel Cabinet 101 KAR 2066, 101 KAR 2102, and 3015. The last two have staff suggested amendments.
101-2066 is being amended to update terminology. 101-2102 is being amended to clarify circumstances for payout of annual leave upon termination from initial probation, clarify character of service upon resignation, clarify the responsibility of an employee to provide prior notice to qualify for paid leave eligibility, clarify that a non-exempt employee's election of compensatory leave or overtime pay is solely the choice of the employee, clarify when to record leave for absentee voting, allow for the appointing authority to temporarily remove an employee from the workplace while an investigation of alleged lack of good behavior or unsatisfactory performance of duties is being conducted, add a subsection for discretionary leave with pay to address instances where an employee is exposed to a situation that requires leave from work for the employee's welfare, and clarify eligibility and the length of time to make up work in the event of adverse weather. 101-3015 is being amended to clarify circumstances for payout of annual leave upon termination other than for cause, clarify character of service upon resignation, clarify the responsibility of an employee to provide prior notice to qualify for paid leave eligibility, clarify that a non-exempt employee's election of compensatory leave or overtime pay is solely the choice of the employee, clarify that the amount of compensatory leave that may be carried to the next pay period is changed to 480 hours for employees in policy-making positions, clarify when to record leave for absentee voting, allow for the appointing authority to temporarily remove an employee from the workplace while an investigation of alleged lack of good behavior or unsatisfactory performance of duties is being conducted, provide that an appointing authority may place a career unclassified employee on administrative leave with pay upon the employee's receipt of an intent to dismiss for cause letter, allow for discretionary leave with pay to address instances where an employee is exposed to a situation that requires leave from work for the employee's welfare, clarify eligibility and the length of time to make up work in the event of adverse weather, and clarify the eligibility for leave for blood donation. The staff suggested amendments to 101-2102 and 3015 amends various sections to comply with the drafting requirements of KRS Chapter 13A.
You can take a breath now. Please identify yourself for the record.
Rosemary Holbrook, I'm the Assistant General Counsel at the Personnel Cabinet.
Mary Elizabeth Bailey, I'm the Commissioner of Department of Human Resources Administration for the Personnel Cabinet.
Thank you so much.
You're welcome.
There are, as he stated, there are staff amendments. Is there a motion for approval of the staff amendments? We have a motion and a second. We have the dynamic duo over there again today. So. Any objections or questions from members on the amendments? Seeing none, without objection, it is so ordered they are approved. So do you have anything to add to that list or anything you want to state?
No, sir, we do not.
Okay. I have one question, and then I'll open it up for other questions. But, you know, in the budget we have, you know, we want a report from personnel for raises and all that sort of thing. Are these regs at all connected to that endeavor, or is this, I'm assuming these are completely separate?
They are completely separate, yes. These are not the compensation regs.
Gotcha. That was, I didn't know if they were connected at all
They are
to
not.
compensation. Okay. That's all I have. Any other questions? Co-Chair Hale.
Thank you, Mr. Chair. And just to clarify, if you could please, in this one section here, it mentioned clarifying when to record leave for absentee voting. Could you just give me a little clarification of what they actually have to do? I mean, is there something that they have to do to request that? Is there a process, something they have to sign?
Yes, there
An
is.
individual?
Yes, there is, sir. We have a voting leave verification form that the employee has to fill out, and they have to tell us when they voted and the county they voted in. And we keep that on file in case at some point we do get audited at times to prove that the employee actually went to vote. And in the past, during the audits, it has been confirmed that some employees did not actually go and vote, and appropriate corrective action was taken against those employees. But yes, we do have a form that they have to verify that they did actually vote.
And then just one quick follow-up, if they so choose not to vote, I mean, they would have to do nothing then, correct? I mean, they would not be given any leave,
Right.
That is accurate.
It's not automatic.
but they do actually have to request
Yes.
that time.
Yes, in advance from their supervisor, yes.
Okay, all right. Thank you very much. Thank you, Mr. Chair.
You're welcome. Any other questions from members? Seeing none, please call the next regulation. Thank you.
Thank you all.
Thank you very much.
Finance and Administration Cabinet, 103 KAR 43340 emergency.
This regulation establishes the average wholesale price of gasoline to be used in the computation of the state excise taxes on gasoline and special fuels imposed under KRS 138-220.
Would you please identify yourself for the record?
Yes, Travis Mayo, General Counsel to the Governor.
Brian Thomas, General Counsel of the Finance and Administration Cabinet.
Could you check that, make sure the green light's on?
I apologize. Brian
There you go.
Thomas, General Counsel of Finance and Administration Cabinet.
Okay.
Bethany Atkins Rice, Executive Director of the Office of Legal Services for the Department of Revenue.
Is your green light on as well?
It is.
Some of those you have to pull a little bit closer, before they can pick up. But sounds great. There are no amendments to this regulation, this emergency regulation. I've got several questions. I'm going to open up to other members if they have questions. Anyone else have questions before I start? Seeing none. So just briefly go through what this E-reg does, please.
Senator, if I could just start by thanking members of this committee and of the General Assembly for their continued support of the people of Eastern Kentucky in response to the flooding disaster, including by posting the Team Eastern Kentucky Flood Relief Fund on the website, as you did for our Team Western Kentucky Tornado Relief Fund on your website. So thank you for that.
We're all in this together.
That's right. And we'll get through it together. We're
That's right.
strong people. And also to thank you for bipartisan support of this emergency regulation action as expressed by Representative Jason Nemus publicly, I believe early last month when he expressed wholehearted support for it and support for the governor requesting the EPA waive the RFG requirements, which he did. So this regulation, came at a time when gas prices were skyrocketing. I believe we were nearing $4.50, and the trend had been going upward. I think the month before it was about 75 cents lower per gallon. The statute at issue here regarding the wholesale price, when that was passed, the General Assembly certainly, I don't think anybody thinks the General Assembly intended for it to impose an increase in the gas tax on Kentuckians when gas prices were soaring like they were earlier this summer. So this, under the authority of KRS 131-130 and KRS 138-226, the department has the authority and for these specific range of taxes, the duty to administer and enforce these taxes and prescribe regulations relating to that administration and enforcement of them. So this was an action to provide relief to Kentuckians who were already hurting not just from soaring gas prices, but from rising costs across the board. And so that's what this does. It froze the gas tax at the same rate it had been the previous 7 years and kept that tax from rising automatically on July 1st of this year. And also provided the department the ability to notify fuel dealers of that action so that, which they're required by statute to do, that the gas tax would remain the same.
So it effectively froze it at 26 point something. Is that correct?
26 cents.
26. Okay.
For regular fuel, and diesel was
Diesel is 23 cents.
23.
Okay. And it was set with this first increase. we have a weird formula that takes, it can quickly go down, but takes a long time to go back up. But this first increase was set to go up 2 or 3 cents, between 2 and 3 cents. Is that correct?
That's correct. It's set to go up 2 cents.
2 cents.
2
Okay.
cents.
What is the impact? We know 2 cents at the pump. So on the backside, going into the road fund, what is the fiscal impact going to be to the road fund?
Well, prior to this emergency regulation being promulgated, and as Secretary Gray testified to, I believe on July 6th,
Yes.
in front of the A&R committee, the joint committee there, that but before the E-reg went into effect and before this action was taken, he stated and stated again then that it would have no material impact on that cabinet's budget and would not compromise any planned and current ongoing road projects. And I believe he stated the impact on the road fund was estimated to be $28.2 million through mid-January, which is about 1.6% of the enacted road fund estimated for fiscal year 23. So that was the impact. But again, as Secretary Gray stated, no material impact on the Transportation Cabinet's budget.
So, and I think that was appropriations and revenue. I'm on that committee, so I've heard that presentation. The $28 million is just from July 1st to the end of the fiscal year. Is that the correct?
Yep, through
Time frame.
mid-January, right, correct.
Mid-January.
right.
Okay. So the impact is $28 million. We can argue whether that's impactful or not.
Estimated is what I believe he
estimated
testified.
impact. And so I'm assuming when you all were discussing this that impact was considered, the impact to the road fund was considered in your negotiations, your thoughts when this was brought forward, correct?
Certainly, and as I stated previously, I think Secretary Gray indicated that no material impact on the cabinet's budget prior to this emergency regulation being promulgated.
With the flooding in eastern Kentucky, do you think anything's changed as far as, let me rephrase that, with the flooding in eastern Kentucky and gas prices now seem to be trending down, has the opinion of the administration changed on impact to road fund and those sorts of questions? Or are we still full speed ahead on this E-reg?
The E-reg is still in effect. I think, as the governor has mentioned in his press conferences, the positives of the gas prices going down. Again, when we promulgated this E-reg, that was the direct opposite trend, and we didn't see an end in sight. And still, predictability of gas prices, I'm not sure any of us can assure would not trend back upward for one reason or another. I know, and rising costs in other areas for Kentuckians continue. So that the E-reg is still in effect, and I would have to defer to the Transportation Cabinet on any effect with the flooding in eastern Kentucky. But my understanding is that it would not have an impact on relief efforts, recovery efforts in eastern Kentucky.
I've just got a couple more questions,
Sure.
and I'll open it back up to other members if they have any questions. But I think you've already stated, but if you could restate it once again, what is the real purpose of the freeze? And kind of where I'm headed is, the KRS that we're talking about is pretty clear that, it's a mathematical formula. And so we're looking at two things. Number one, does the administration have the authority to do it? And secondly, is it really going to do what the administration intends for it to do? So let me start there and tee it up and say,
Sure.
What is the real impact on the average Kentuckian? So if an average person goes to the pump, how much is this really going to save them at the pump?
Well, the purpose is to help Kentuckians when they're hurting, and a little help is a lot better than no help at all. So any relief we can provide to Kentuckians when you have rising costs is helpful for Kentuckians. It helps folks. So that's the purpose. And the statutes, we believe, again, I'll restate, I don't think when they were passed, the General Assembly meant for them to impose a gas tax hike at a time when Kentuckians were paying more and more at the pump and in other areas of their daily lives and having to make tough decisions based on those rising costs. So, again, a little help goes a long way. It's better than no help at all. And that's the purpose and intent of this freeze before July 1st when prices were soaring. And, again, keeps the tax rate the same it had been for 7 years. We believe that the statutes provide that authority for the department to administer these tax laws, and that the statute at issue that sets this was meant to have some flexibility throughout the year when there are rising costs such as we faced here, and action needed to be taken to help folks.
But do we have any numbers like the average taxpayer, going to the pump? How much is this going to save them per fill up? Obviously, I don't know what the average person, how many gallons they get when they fill up. So let's say they get 15, and then this is going to save the average taxpayer 30 cents per fill up. But do we know what the average fill up, the gallons per fill up is? Or
I don't have them in front of me in terms of knowing what different types of vehicles, what per gallon average these vehicles might get, and the average for Kentuckians specifically. But we'd be glad to follow up with the committee members on any specifics we have.
Okay. And the reason, something we have to consider as a legislature, and obviously the executive branch has to consider this as well, is we've got about 75 bridges out in eastern Kentucky. And have you been in talks with the Transportation Cabinet about, where that money's coming from to repair those bridges? And because we're going to, $28 million, that would repair several bridges in eastern Kentucky. And we understand it's a balancing act, right? We're balancing interests. And so, but is that being considered?
I can tell you, ongoing assessments in eastern Kentucky, including on bridges and roads, as I'm sure you all are aware, and those are going to continue because for a while to determine the extent of the true extent of the damage in eastern Kentucky across those counties. But I know that part of that assessment is discussing where funding could come from, including from the federal level. I'm in communication with not on that issue, but other questions and issues that might arise with FEMA on a daily basis to make sure that to tell them we need to do the right thing here for Kentuckians. And so, that assessment's ongoing. And, I know we are committed to, as you all are, to providing whatever's necessary for Kentuckians in eastern Kentucky to repair all the damage, including bridges, and to, rebuild coming out of the recovery.
Thank you. I've got one final question, but before I ask that question, I'm gonna back up. Do we have any other questions from members? Senator Alvarado.
Thank you, Mr. Chairman. In your comments, you said that you couldn't imagine that the General Assembly's intent was with the law that had been passed. Many of us here today were people who voted on that legislation. Did the administration even reach out to any members of the General Assembly prior to taking this action? If you wanted to know the intent and what we intended to do when we passed it, so many of us are still here that voted for that. I didn't get a phone call. I don't think anybody on this committee got a phone call. Did the governor or anybody from his administration bother to reach out and ask?
What I can tell you is that as in the last session, Senate Joint Resolution 99, which the Senate did pass, related to motor vehicle taxes, and that relayed that the governor had authority to act there, similarly to how he acted here to freeze a tax on Kentuckians at a time when rising costs were occurring.
Well, thank you. I mean, that was applying to a state of emergency, which no longer exists, however, is the condition. And you quoted, I think, 138.226, which I have here before me. The department shall administer the taxes provided under KRS 138210, 448, 450, 470, except 463 and 4631, and may prescribe, adopt, and enforce administrative regulations relating to the administration and enforcement thereof. And the department shall, upon the request of the officials to whom are entrusted the enforcement of the motor fuels tax law of any other state, the U.S., the provinces of the Dominion of Canada, forward to such officials any information which it may have relative to the manufacture, receipt, sale, use, transportation, shipment, or delivery by any person of motor fuels, provided such other state or states provide for the furnishing of like information to this state. That's what the entire statute says. So somehow in there you think, well, this gives us the authority to freeze taxes that it clearly says you have to administer, provided under that. I want to know how you guys can interpret that. I mean, it's clear that we said, this is what we need to do. Here's the formula we set forth. We had a big debate on the Senate floor. I remember that distinctly. And people cast votes on that. People sent us here to cast votes on that, only to have one guy who has the people before him that he can call. You guys can call any of us. Contact us. Send us a letter. What do you think about this? We're thinking about doing this. Was this your intent? Would you like to see this happen? No, we're not going to bother to contact anybody. We're just going to decide ourselves because we have a scepter and we think we're kings and this is what we're going to do. I find this kind of ruling from an administration ridiculous. When you have people that are willing, when there's the thought of we're all in this together. No, we're not. Not at least by your guys' notion. It's we're going to do this. We're going to do things. One person make a decision, roll it out there, and try to explain it afterwards. When you could have incorporated any of us in the opinions of many people, even our leadership, who have been here for a long time and have been here when these laws were enforced. No one bothers to do that. That bothers the fire out of me. I think it bothers the fire out of most Kentuckians. So, again, I don't think you have the authority to do these kinds of things. If you want to incorporate them and ask, you can ask members of the legislature who are here and willing to talk. But this has been a common theme. There's no interest in discussions. The interest is addressing it through a television camera, giving speeches every day, instead of coming and talking to the people that have been elected here as well to basically enact these laws. So, Mr. Chairman, again, this bothers me when this comes before us, and it's a usurpation, really, of one branch of government completely, when there's an opportunity for them to come and talk to members of the General Assembly prior to enacting these kinds of regulations. Thank you.
Thank you, Senator Alvarado. Yes, just to chime in and echo some of what Senator Alvarado has stated, I'm painfully aware of the gas tax formula because I was sworn into the Senate in 2015 at noon and had to vote on the gas tax either that day or the next day. So that was one of my first votes in the Senate. So I'm painfully aware of we definitely thought about it, and we have intent when we put this formula into place. We can argue whether it's right or wrong. But moving on from there, I'm not going to make a motion for deficiency today, but this reg will move on to A&R, and there can possibly be a deficiency motion there. And we do have a real question as to whether this exceeds the governor's statutory authority to do this at this time. In your opinion, and you may or may not have consulted him on this, but we hear a lot of talk about a special session associated with Eastern Kentucky. Do you think the governor would be willing to make this issue part of the call? And so if he really wanted for the legislature to chime in and to make a statement, do you think he'd be willing to make that part of the call where we could legislatively freeze it for a certain period of time? Do you think he would be willing to do that?
That hasn't been brought up in my discussion, so I haven't consulted with anyone on that. But I thank you for bringing that up here at the committee today.
Okay, I would suggest that line of communication that he could talk to us, and maybe that could be considered as part of a special session and part of the call. So.
And Senator, if I may, just to follow
Sure.
up
Yeah,
on something
proceed.
about earlier on the recovery in Eastern Kentucky, I know we do have a large general fund surplus that helps there too. And again, in response to Senator Alvarado's concerns and yours, Senator West, again, we do not interpret the statutes in a way meant to increase the cost of gas at times when of great cost. So I wanted to reiterate that as well.
I'm going to move on to Senator Yates has a question.
Thank you, Mr. Chair. I think he just touched on it. I was going to ask about the interpretation, but thank you.
Thank you,
Okay.
Senator.
Co-Chair Hale.
Thank you, Chairman West, in conversations with two county judge executives in my district, small counties, rural counties, they brought to my they brought to questions as I attended their fiscal court meetings about the impact, even though it's just 2 cents, but the impact was going to affect them, not an incredible amount, but in those counties with primarily rural roads in their counties, they felt like this could be could have a detrimental impact on funds that they would not receive. And again, they had concerns about that. I may be wrong on my calculation on this, but I think I'm close. The question was brought up about the savings. I think the savings, and based on the amount of gallons you buy and the amount of what you're getting per gallon on your vehicle, but giving a range, I think the savings would be somewhere between $13 and $20 per year, less than $1 a month, or a little over $1 a month, $1.25 a month. So that's not a great savings when we look at the impact that this could have on some of our, especially our rural roads, when we're talking about a savings of somewhere between $13 and $20 per year.
And
would you like to comment on that?
Sure, Representative. And again, not knowing exact estimates, having done those myself, but in response to your first concern of the two county judge executives, I think you referenced that you had spoken to. I believe the governor has committed to propose to make local governments whole in the next regular session. So I did want to respond that way. And any concerns you have, that we're glad to speak to county officials who have concerns and to try to address them and reassure them. And again, in terms of the estimated savings for Kentuckians, it's some relief is better than none. And I'll just keep saying that. I can tell you I was down in Eastern Kentucky this past weekend, and I can't imagine, I wasn't even in the worst parts that were affected by the devastation. But talking to people who just want you to listen or give you the name of someone they can reach out to or an address or where they can go apply for assistance, and following up with them means the world to them. And that's just a little help that goes a long way. And in that tone, if there are any other questions, Senator, I did want to just have a closing remark, if possible.
Do we have any
Sure.
other questions? Please proceed.
I know that you are supporting these relief funds for these disasters we've unfortunately had right back to back this past 9 months, not even. But I wanted to let folks know too, and feel free to reach out to me if you need any specifics or questions or ways to get this out to your constituents. But the other funds that are available to help Kentuckians during this time, we have our Eviction Relief Fund, which July of last month sent out more than about $13.3 million. That was a 45% increase from June, of showing that that's an issue that is increasing, and there to help landlords and renters with utilities and rent. Our Homeowners Assistance Fund, our Nonprofit Relief Fund, which I think as of last Friday have received more than 500 applications requesting over $35 million. Our Affordable Connectivity Assistance for broadband. So I just wanted to mention those funds that can provide some help to Kentuckians out there outside of this awful disaster we have in Eastern Kentucky, and in addition to the relief that they can receive from various resources at the state government level and the federal government level. And again, if y'all have need any information about those, you can reach out to me directly and I'll get you an answer immediately.
Thank you for that. Any other comments? Seeing none, please call the next regulation. Thank you.
Thank you, Senator.
Kentucky
Representative.
Retirement Systems, 105 KAR 1 450.
This regulation establishes the forms and procedures for quasi-governmental agency employers participating in the Kentucky Employees Retirement System to report persons serving as independent contractors and leased employees. There is not a staff amendment.
Please identify yourself for the record.
Hi, I'm Carrie Bass. I'm a staff attorney supervisor with the Kentucky Public Pensions Authority.
And I'm Jessica Bovian. I'm a policy specialist with the Kentucky Public Pensions Authority.
Could you check that mic real quick, please?
Oh, sorry.
There you go.
Jessica Bovian, policy specialist with the Kentucky Public Pensions Authority.
Thank you. There are no amendments to these regs. Any questions from members? Seeing none, please call the next regulation. Thank you.
Boards and Commissions, Board of Architects, 201 KAR 19035 and 87. Both have staff suggested amendments.
201-19-035 is being amended to provide the Kentucky Board of Architects the discretion of verifying an examination applicant is of good moral character rather than the mandatory obligation of verifying it, and update the titles and additions of material incorporated by reference. 201-19-087 is being amended to update the process for reporting continuing education courses. The staff suggested amendments to these regulations amend various sections and the material incorporated by reference to comply with the drafting requirements of KRS Chapter 13A and make technical changes.
Would you please identify yourself for the record?
My name is Cordelia Harbert. I'm with the Kentucky Board of Architects. I'm the executive director.
Okay. There are staff amendments. Is there a motion for approval of the staff amendments? We have a motion. We have a second. Without objection, is so ordered. Do we have any questions from members on this set of regs? Seeing none, please call the next set of regulations. Thank you.
Thank you.
Board of Emergency Medical Services, 202 KAR 7560.
202 KR 7560 amends to delete the requirement to have an on-duty paramedic staffing at least 25% of the agency's staffed ambulances at any time during a 24-hour period. Change emergency medical technician to emergency medical responder as a requirement for drivers of all classes of ground ambulances, and delete requirement for a certified emergency medical responders who were drivers prior to January 1, 2018, to be employed by the same agency in order to continue to be drivers.
Would you please identify yourself for the record?
Good afternoon. John Wood, outside counsel for the Kentucky Board of EMS.
Eddie Sloan, Kentucky Board of EMS.
Could you check that mic, please, sir?
Sorry. Eddie Sloan, Kentucky Board of EMS.
Thank you. There are no amendments, so we'll move right into questions. Senator Alvarado, I'll let you start.
Just why do we need this regulation, if you can explain the reasoning behind it?
So specifically, which of the parts, I guess, is there one part first that you would like to me address?
Well, it's but having less requirements for EMS to be present during certain runs. If you could explain as to why we need to do some of those.
So the EMR will lower the requirements just a bit for the driver. It will not lower the requirements for the attendant. And currently there are some regulations we've been using on and off for the past couple of years that allows a CPR and first aid, or CPR and driver trained to drive the ambulance. So this will give some training, minimum training, but a little bit less than the EMT. And the agencies can get those members trained much faster than they can the others.
Thank you.
I'll follow up with Senator Alvarado's question. When I read the summary, it made it appear like we were making these ambulances less safe because you don't have to have a paramedic on there as often in the 24-hour period and that sort of thing. So I know you covered it at a high level, but if you could just, like a normal ambulance, like a rural ambulance service who has 5 ambulances.
Sure.
How will this reg affect them?
So quite frankly, the bottom line is there's just not the staff to do the 25%, and there's no hiding that. So when you look in the rural areas, there were some cases, and as you talk about in particular, maybe doing more basic level runs or something. Well, agencies are running up against a wall. They said at least we could put on a BLS crew, but we can only we only have enough paramedics to do 4 ambulances. That 5th ambulance would trigger another paramedic. And so some is better than none is I think the takeaway from there. But quite frankly, we can't meet the demand with the number of paramedics in the state currently.
So it is, bottom line, it's going to be less safe because there's not as many paramedics. There's not enough paramedics out there to staff these ambulances.
That's the bottom
line.
line.
Your reg is responding to, you're not causing the issue. The issue is you're responding to an issue.
It's out of necessity. Yes, sir.
Gotcha. Any other questions? Senator Yates.
Thank you, Mr. Chair. I've litigated some negligence cases related to ambulance runs, and our standard of care is already pretty low in Kentucky compared to other places. And so it worries me right now if we're going to sit in this room and we're going to pass a reg to make it even less safe for our constituents. If we look at all the things that we do, I would think that public safety should be a top priority. Now, I understand I'm not chastising you guys here because you're dealing with what you got, but would there be other ways to incentivize proper training? If you brought in to, if there's just an EMR, to have someone a period of time that you have 6 months to be EMT trained once you're hired on, and then there's that pay incentive. I get it, you're gonna have to put your money where your mouth is, but shouldn't that be a primary obligation to this government, is public safety? You think about all the things we spend money on, and we know by making this amendment, by making this change, by not having trained drivers, people are gonna die. We know that, right? It's less safe.
So first, I don't know that I'm willing to agree that the standard of care in Kentucky is less than that of neighboring states. So
other states, right?
Of other states. So I don't know that I would concede to that right off. But with that being said, would it be preferable to have a paramedic on every ambulance? Absolutely, it would be preferable. If there were more money and funding, absolutely, that would be greater. It's not the cards we're dealt today. And so I do think there's some things that we're doing, and as part of House Bill 777 and others, we're trying to take those actions, but they're just not in place today. Perhaps in the near future they will be.
Again, we're all on the same team here.
Sure.
And so I think I'd feel a lot more comfortable if the request today was for additional funding for these services as opposed to a request to just lower the standard of care. I'm not going to ask for a deficiency because I understand the predicament, but I did want to bring attention to this body that we got a major problem. I know we got a major problem across all these thresholds, but this is one where we know that other areas have incentivized. They've taken some of our talent, and they've done that by throwing bucks where the problem is. We're going to have to compete. And we are below a lot of other states, and I know that just by bringing in experts from some of my cases. And part of me being elected is to bring us back up.
So
Thank you.
Your point's well taken on the funding, and I think that's loud and clear to the board, and I think that you will see some requests for that in the future.
Any other questions from members? Yeah, I would like to echo some of what Senator Yates has stated. I don't think this is the proper time to call for deficiency or anything like that because you guys are wrapped up in a much larger issue, the workforce issue that we as a legislature are attempting to grapple with, and so it's. Thanks for the explanation. I have nothing else to add. Any other questions from members? Seeing none, please call the next regulation. Thank you.
Thank you.
Heritage Council, 300 KAR 6011 emergency.
300-6011 emergency establishes the application process to determine a taxpayer's eligibility to claim a certified historic structure rehabilitation tax credit.
Would you please identify yourself for the record?
Thank you, sir. Good afternoon. My name is Craig Potts. I'm the director of the Kentucky Heritage Council.
And I'm Sarah Cronin. I'm the general counsel at the Tourism, Arts, and Heritage Cabinet.
Thank you so much. We have no amendments on this reg. Any questions from members? Seeing none, please call the next regulation. Thank you.
Thank you.
Thank you.
Board of Education, 702 KAR 140 with staff suggested amendment.
This regulation is being amended to clarify who will conduct the hearing, who will appoint the person who conducts the hearing, cite the federal statute that mandates a hearing, and that a hearing will be available to a parent or eligible student, and update language for consistency with FERPA and KRS 16730. The staff suggested amendment amends various sections to comply with the drafting requirements of KRS Chapter 13A and make technical changes.
Would you please identify yourself for the record?
Good afternoon. Todd Allen, General Counsel for the State Board of Education and Department of Education.
Thank you so much. There is a staff amendment. Is there a motion for approval of the staff amendment? We have a motion and a second. Without objection, it is so ordered. Any other question? Any questions from members on this? I have one question. So, across the country, we're seeing, parents chime in at school board meetings and be more and more involved in their child's education. I think that's probably one of the highlights or the silver linings of COVID is parents have been able to see what happens in their day-to-day education of their children. And so this kind of is around deals with the edges of that. And so could you explain to the committee, what does a current situation look like, and then how will this change that?
Sure. So the regulation is designed not to really change anything. It was designed to provide clarity because we had some questions from school districts about how this operates. We have both federal law, FERPA, the Family Educational Rights and Privacy Act that governs this topic, as well as parallel state law, Kentucky FERPA. And so we needed a regulation that complies with both of those. They're very similar to one another. And the language that was in this regulation hadn't been updated in many years and was rather confusing. So, for example, you see references just to the parent, but both FERPA and Kentucky FERPA reference a parent or eligible student, and typically an eligible student is one who's reached 18 years old, so they have the decision-making rights at that point in time, and the right to the hearing would be theirs. So this really doesn't change anything from the current situation. If someone has a problem with an educational record that's created at the school, whether it's a student report card, a disciplinary report, something of that nature, I would say that most of the time in Kentucky public schools, those are handled informally through contact with the parent to the principal or someone at the district level, and most things are taken care of. In the event they cannot get the matter resolved informally in that nature, then this provides the right to a hearing where the parent can come forth with a neutral third party, a district employee, but neutral nonetheless, so not the student's teacher or principal, to decide the matter, whether or not the education record needs to be amended.
So the main question I have is, as a parent, that parent has a right to their child's, let's say it's the parent of a child who's under 18.
Yep.
They have a full right to that child's educational records, I'm assuming. Is that a fair statement?
Yes. Absent, some type of court order transferring custody to some other individual, yes.
Right, some other outside legal issue.
Right.
So this reg does nothing to change that fact, and
No.
in most cases, the parent, if they want a copy of a record, all they got to do is ask the
That's right.
principal or somebody at the school. And so, give me an example of a situation where this might arise. Like you've already exhausted your efforts the first go around, and you're now into the hearing phase. So what would be an example of a hearing that might take place?
So they're rather informal. What the change in this regulation was really designed to clarify, it previously referenced a certified individual, and school districts contacted us and said, do you mean a certified teacher who's certified by the Education Professional Standards Board, or do you mean a certified hearing officer? We're confused. That was the whole reason that we updated the regulation. We removed the language around certified completely because we determined that neither federal nor state law require it to be a hearing officer under KRS 13B, and it doesn't require it to be a certified individual. So there may be a classified person in the school district who can oversee and conduct that hearing. They happen very infrequently, thankfully. School districts around the state all have policies in their policies and procedures manual that govern this. But it would be a rather informal hearing where a school district employee appointed by the superintendent comes forward and presides over the hearing, and both of the parties put on their arguments and case as to why the current education record is inaccurate or misleading in some way. I would say that most often relates to disciplinary records, but it doesn't have to.
So the main effort would be to the parent has a problem or an issue with the records and they want those changed. That's the main issue.
Correct.
Okay. I have no further questions. Do we have any questions from members? Seeing none, thank you so much.
Thank you.
Please call the next regulation.
Labor Cabinet Office of Unemployment Insurance, 787 KAR 1360 with staff suggested amendment.
787-1360 amends provisions for overpayment waivers pursuant to House Bill 1 from the 2022 session to extend the time period to waive an overpayment of benefits for unemployment insurance. The staff suggested amendment amends various sections to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
Sure. Good afternoon. Orrin McFarland, Deputy General Counsel, Education Labor Cabinet.
Thank you. We have a staff amendment. Is there a motion for approval of the staff amendment? We have a motion and a second. Without objection, it is so ordered. Any questions from members? Seeing none, please call the next regulation. Thank you.
Thank you all.
Department of Workers Claims, 803 KAR 25195 emergency.
803-25195 emergency establishes workers' claims utilization review procedures for injured workers. The amended after comments version adds and clarifies definitions, clarifies claim selection criteria, revises deadlines, and clarifies peer-to-peer conference provisions.
Would you please identify yourself for the record?
Good afternoon. My name is Scott Wilhoit. I am the Commissioner of the Department of Workers' Claims. Pleasure to meet you all.
Thank you.
I'm Dale Hamblin. I am the Assistant General Counsel for the Workers' Claims Legal Division.
Thank you. There are no amendments. Do we have any questions from members on these regulations? Seeing none, the committee will stand at ease for just one moment. I've got a couple questions, and you guys are well aware because I know you've been involved in this issue. We've been involved in this issue for a year or so, and when we had a reg that was found deficient, dealt with the medical director and all that sort of thing. So please compare the reg that was found deficient and this regulation. I know we've taken out medical director
Yes.
entirely.
Yes.
So if you could go through what's remaining.
In large part, it is what existed prior to the amendment with a medical director. It basically gives a set of guidance to folks going through utilization review. I'm not sure if you're all aware of what utilization review is, but utilization review gives an employer an opportunity to determine whether proposed or actually past medical treatment was reasonable and necessary, and the best course of action. That also allows then the employee not to receive unneeded medical treatment, that sort of thing. We now, of course, have treatment guidelines, and all the utilization review now is directed to use those guidelines when they're actually assessing that treatment.
So, real quickly, if you could, I know it's fairly complicated, but compare how the process currently works and how it's currently reviewed, and how this will change the existing process.
Well, it actually depends on what you mean by existing. The prior with the medical director, you had a second level of I should back up and say you went to an initial.
Let me clarify.
Okay.
Let's take the medical director, that deficient reg, take it off the table.
Sure. Okay.
Compare this to what we currently have in place.
Basically, it's the same as it was before, with the exception of we changed some of the dates so that they were all business dates rather than calendar dates and some business, that kind of thing. We also
So we're
added,
tweaking the chronology of the, the review.
Yes,
Okay.
we had some comments about some dates just not matching up because utilization review is referenced in other regulations, and some of those dates didn't match up. And so we added some of those and some conditions that didn't exist before. We didn't have peer-to-peer before, so we had to add what we call peer-to-peer. Peer-to-peer is simply where a treating physician, they requested pre-authorization for a treatment. That treatment got denied, then the treating doctor has a right then to ask for a peer-to-peer review with someone of like qualifications, and actually sets a time and a phone number and so forth that the reviewing physician can call. So everybody's
is that new? Is that new?
That is new. It came in with the treatment guidelines and the formulary regulations.
And Senator West, if I may add, just real quick, it's actually afforded us an opportunity to do a lot of cleanup on some things that, as you just mentioned, tweaking since this regulation was originally in effect back in 1996. For instance, the idea about the business days versus calendar days, some confusion. I've been practicing law for workers' comp for over 30 years, and that was a confusing, and I always said, be on the safe side, let's go with the shorter days as opposed to the more. And also, too, what we've also tried to do is define better what does, again, on specialty and so forth. So we have neuro to ortho, or we have some sort of comparison of what we're talking about. It gave us a great opportunity with the feedback we received from the stakeholders on what we can do to tweak this. And of course, we're also going to be coming back with 195 regular, and we're going to be using some of those statements as well. With this, mainly, this is how would I say 190 2.0. We've gone back together and tried to tweak it and make it fair and makes more sense on problems that people came forward. So we took that as advantage to change that.
Okay, thank you. Sounds fine to me. Any questions from members? Seeing none, please call the next regulation. Thank you.
Thank you, sir.
Kentucky Horse Racing Commission, 810 KAR 8010 and 9010, both with staff suggested amendment.
8010 amends the split sample testing procedures to require the owner or trainer to select a laboratory within 5 days and the sample to be shipped within the following 7 days. 9010 amends to allow the commission or its executive director to publicly disclose information about an alleged violation if the information will not unduly impact an investigation, requires that a steward's or judge's hearing be conducted within 60 days after the notification of a violation or the receipt of the split laboratory results if requested. It allows the stewards or judges to extend the hearing date upon demonstration of exigent circumstances and allows public attendance at stewards or judges' hearings. The staff suggested amendments amend various sections to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
Thank you. Jamie Eads, Interim Executive Director.
Sean Dutta, Deputy General Counsel.
Thank you so much. As mentioned, we have staff amendments. Is there a motion for approval of the staff amendments? We have a motion and a second. Without objection, it is so ordered. Any questions from members on this set of regulations? I'm sorry, I'm just loaded with questions today. So I'm assuming these are, when it says split sample, it's talking about, the owner of the horse pulls their own sample, and then that's when those conflict with.
Well, we pull the samples, and one goes to our lab, and if it's positive, they have the right to come back and ask for the split to be sampled at a lab of their choice.
Right. And when they choose the lab that they like, and it comes back with a different result, that's what this is talking about, correct? Is procedures for.
This was in the best interest of transparency. So I think what this is allowing us to do as an agency is to be more forthcoming with positives before we get to even the point of the split.
Oh, okay. I got you.
Senator,
I was confused on that. I got you. Okay.
Yeah, Senator, the split sample testing, that part is not changed. It's just the timeline to get that, request that testing. There's a timeline on that now.
Gotcha. I didn't read enough. I apologize. Any other questions? Seeing none, please call the next regulation. Thank you.
Thank you all.
Department for Public Health, 902 KAR 4030, also 902 KAR 8060 and 100 with staff suggested amendments, 902 KAR 10140, and 902 120. Both of those also have staff suggested.
902 4030 amends to allow test results to be transmitted electronically.
902 KR 8060 amends to clarify the reclassification process for local health department employees, remove the Department for Public Health approval for a local board of health to give a local health department director a discretionary pay increase, and remove the 5% limit on the discretionary pay increase for local health department directors. 902 KR 8100 amends to clarify the situations that may warrant disciplinary action and make technical and other corrections to comply with KRS Chapter 13A. 8060 and 8100 both have staff amendments that make changes to comply with KRS Chapter 13A. 902 KR 10140 amends to clarify that probationary and provisional certification are equal, add a fee of $45 for certification renewal and advancing to the next level of certification, including to clarify that the fee is paid to the Environmental Management Branch in the Department for Public Health. Add certification requirements for progression to the master certification level, including to tier continuing education requirements for installers certified at the master level to be 6 hours every 2 years, and make technical corrections. The staff amendment for 10140 amends various sections to comply with KRS Chapter 13A. 902 KR 3120 amends to clarify evaluation procedures and assessment processes for those infants and toddlers who are referred for early intervention services, expand eligibility for infants and toddlers with hearing loss, and update material incorporated by reference, including to provide a website link to the material. The staff amendment amends various sections to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
Julie Brooks, Regulations Coordinator for the Department for Public Health.
Thank you. There are staff amendments. Is there a motion for approval of staff amendments? We have a motion and a second. Without objection, it is so ordered. I believe Senator Alvarado has a question.
Just really quickly on the 060 on the salary adjustments for local health departments. Looking at the fiscal note at the end of this, this is going to be passed on to local health departments to absorb the cost. Is that correct? If there's increases for this, are these decisions made? If you could explain a bit for this, because I mean, it sounds like there's, the way it was described is a 5% increase it can be, and it can be above that amount. How much are we looking at for increased costs? Because we've had numerous sessions in a row where local health departments are saying, please, we're underfunded, give us more funds, we need more. And now this looks like it's going to be something that can potentially increase those costs. If you could explain that.
I can try. This is actually at the request of local health department directors. The process is currently that if a local board of health wants to provide a discretionary increase or a salary increase for the local health department director, they have to seek approval of that from the Commissioner for the Department for Public Health. So this just would remove that layer. Currently, the burden for funding that lies with the local health departments as it is currently, so it doesn't really change as far as that funding.
It just gives the local folks more authority, and they don't have to seek approval from the state, is what it sounds like.
Yes.
Okay, thank you.
Along that line, is there a cap on, I mean, we're theoretically removing the 5%, and well, the approval from the state of the 5%. So is it unlimited now? So it's total discretion at the local level.
Yes.
Okay. I have no questions on that. Any other questions? Seeing none, please call the next regulation. Thank you.
Thank you.
Department for Medicaid Services, 907 KAR 23020 emergency.
This regulation amends to allow certain substance use disorder drugs to receive additional dispensing fees per month by allowing the fee to be available once every 7 days. It updates 340B data tracking measures. It removes cost-sharing requirements in accordance with 21 regular session Senate Bill 55 and clarifies that both in-house and contract 340B pharmacy reimbursements do not include the 340B ceiling price and the lowest of logic methodology.
Please identify yourself for the record.
Good afternoon. I'm Jonathan Scott, Regulatory and Legislative Advisor for the Department for Medicaid Services.
Thank you. There are no amendments, so we can discuss the regulation at hand. Do you have any questions from members on this set of regs? If you could just briefly go through, I know this is a very, very important issue of, you know, people who are in recovery who are relying on these drugs to get through the day. Are they constantly having to get refills and go back? And then I know we have the PBMs, you know, behind some of this, you know, trying to rein in costs, but do you think it's working well now?
That was a change we made when we refiled. We had originally, we were just doing a monthly.
Could you pull that mic just
Sorry
a little
about
bit
that.
closer?
That was a change that we made when we refiled this this administrative regulation back in June. We had originally had it out there as an emergency, and we needed to make the 340B changes. And so at the same time, we had completed an analysis that we decided we were going to switch to this for certain qualifying SUD drugs, MAT drugs, medication-assisted treatment drugs. We were going to allow for the possibility of a once every 7-day dispensing fee instead of a monthly or once every 23-day dispensing fee for just for drugs that meet the applicable standard of care, and that's what's published in the KBN and the KBML regulations. It should, yes. Yes.
Okay.
We don't necessarily know that there would have been a large impact to the to the recipient beforehand, but this will help with reimbursement for the pharmacy providers.
Any further questions? Senator Alvarado.
Just to be clear, Jonathan, because this is a hot topic. We know this has been a big issue. So the way I'm reading the regulation then is if someone, for example, has Suboxone, which typically if it's a pill form, people have to go in when they're first inducted on this drug and they're first started on it to go through substance use recovery. They have to come in frequently every week to get, or sometimes within 4 days, 5 days, they get a prescription, have to come back in, get drug tested again, go back to the pharmacy for the next prescription because they don't have refills on it to get it filled. The issue was the filling rate for that. We heard from a lot of pharmacists. So the way I read this is they can be reimbursed once every 7 days. Is that correct for those drugs if it meets the KBML and KBN regulations?
Right. If it meets the applicable standard of care, then so I think there are just a couple of MAT drugs that will meet that.
And there's others I know that are injectables that, you know, perhaps to go in monthly so they don't have to have that. But that was the biggest issue I think we heard from a lot of folks. It sounds like this is a compromise to that issue.
We did make that change.
All right.
Yes.
Thank you.
Any other questions or comments? Thank you, sir, for being with us today. Please call the next regulation at this time.
Department for Community-Based Services, 922 KAR 1310 with a staff suggested amendment and an agency amendment. 922 KAR 1315 with a staff suggested amendment, and 922 KAR 1340.
922-1310 amends standards for child placing agencies related to foster care or youth in custody of the cabinet to establish requirements for the foster care home registry, establish requirements for agencies related to foster homes that have been closed or put under corrective action, delete standards for private child placing agencies because these standards have been placed into another regulation, and make technical corrections and updates for consistency with 922-1340. The amended after comments version adds one definition, increases from 6 to 10 the minimum hours of annual foster home training, deletes provisions pertaining to therapeutic foster care homes, and updates incorporated material. The staff suggested amendment amends various sections to comply with KRS Chapter 13A. The proposed agency amendment amends Section 2 to clarify requirements to resume work for an employee under indictment, legally charged with felonious conduct, or subject to a cabinet investigation, and updates material incorporated by reference to clarify information regarding medically complex homes.
922 KR 1315 establishes standards for child placing agencies that provide contracted foster care and adoptive placements for children who are not in the custody of the Cabinet for Health and Family Services, consistent with model federal standards, including many requirements previously contained in 922 KR 1310. The amended after comments version adds a definition for independent living services and makes changes for clarity. The staff suggested amendment amends various sections for clarity and to comply with CARES Chapter 13A. 922 KR 1340 amends to establish requirements for independent living sites, including a scattered or supervised site in which children in the custody of the Cabinet who are at a certain age may be placed by a private child care placing agency. Expand the independent living programming to include topics such as benefits available to former foster children, financial literacy and career exploration, and correct citations.
Please identify yourself for the record.
Good afternoon. My name is Laura Began, and I'm the Regulation Coordinator for the Department for Community-Based Services.
Thank you so much. There are staff amendments. Is there a motion for approval of the staff amendments? There is a motion and a second. Without objection, so ordered. There is also an agency amendment. Is there any discussion on the agency amendment? Seeing none, is there a motion for approval of the agency amendment? We have a motion and a second. Without objection, so ordered. So we have before us the regulations with added staff amendments and an agency amendment. Any questions from members? Co-Chair Hale.
Thank you, Co-Chair. My only question is on 001-310, on the section there that states that the increase from 6 to 10 hours, the minimum hours of the annual foster home training. I'm not speaking against that. I'm just saying what precipitated that change from 6 to 10?
Yes, sir. Honestly, that was just cleanup that had changed in other administrative regulations in years past. So that's actually been the standard for some time. It should have been cleaned up in this regulation years ago with the others.
So it's always been 10?
For the past few years, yes.
Okay, thank you. Appreciate that.
Any other questions from members? Seeing none, thank you so much.
Thank you.
We do not have a regulation to call. That is the end of this meeting. Do we have, I'm sure staff will talk to us about dates for our next meeting.
We are currently scheduled for September 13th, which is the second Tuesday in September at 1 p.m.
Okay. Any other questions or information to come before the committee? Seeing none, this meeting is adjourned.